Ready?
All right, we're back on the record, and the court took some time to reflect on the arguments that they thought were good on both sides. And as a preamble, I would like to say that, COVID's a real threat, and there is a very strong public interest in the safety of the community, and that everybody should comply with the state regulations regarding social distancing and masks. But that also has to be balanced against constitutional rights of citizens, the Ohio Constitution, and thousands of jobs, and that is a delicate balance. I do appreciate council's attempt to enact a law that didn't shut everybody down, all the bars and restaurants, and they tried to seek this balance. However, I am going to go ahead and grant the temporary injunction, temporary restraining order. And I'm going to give you the reasons why. And there'll be a full hearing later. This is temporary, but I am going to grant the order. I do believe that the plaintiffs have shown a likelihood of success on the merits, although I do think Mr. Spurlock's argument was a pretty good argument, a little clever, in that the ordinance doesn't prohibit the sale of alcohol. It prohibits congregating and consuming after 10 p.m. However, as Mr. Hasty pointed out, state law and the state liquor statutes permit consumption and congregating and the sale of alcohol, besides the sale of alcohol, after 10 p.m. So I believe there is, in my mind, a likelihood that the plaintiffs could succeed on the merits on the home rule argument. As far as other constitutional arguments go, I'm not going to opine on that a lot. I'll leave that to Judge Fry. But it does seem somewhat arbitrary to me to determine, without a full hearing, without expert evidence, to single out restaurants and bars versus other large gathering places, bowling alleys, churches. I heard the governor today say he's going to allow the 4-H junior fair, and I think they're going to limit who can go and how many people can congregate. But we already have those rules in place for restaurants and bars. And I do think we have the tools in place if, in fact, the increase in positive tests can be linked to restaurants and bars. Let's have a full hearing and let's decide that, but we still must comply with home rule. Now, part of your argument, Mr. Hasty, and the plaintiffs may be undercut if the governor on Thursday determines that he's issuing a statewide order that determines that alcohol cannot be consumed in congregations in restaurants and bars after 10 p.m. And we'll see what he does, but right now, I believe it violates home rule, and Judge Fry can take that matter up. Now, again, we're only allowed to have court every other week. This order is a temporary clause for 14 days. What I'm going to direct you to do after I go through the rest of my analysis is you'll have to see Judge Fry's staff attorney and pick a date and time for a full evidentiary hearing, or however Judge Fry wants to handle that matter. And then it will be in his hands. Again, I do think counsel tried to reach a middle ground, and I appreciate that, but you still have to comply with the Ohio Constitution. I do believe the plaintiffs have shown in paragraph 62 of the affidavit and other paragraphs, and I believe it's true that the plaintiffs will suffer irreparable harm. Business is already on the decline, 60 and 80% for some of these businesses. They would be out of business if, and a lot of these businesses, they do a substantial amount of the business from 10 p.m. on, which I understand supports your argument that, hey, there's a lot of people, but the tools are in place. Enforce the law. If you go and people are standing shoulder to shoulder, close the bar down. Punish the people that are violating the law. Those safeguards, I think, are already in place, and I think the plaintiffs will suffer irreparable harm. They would never be able to reopen. And we're talking about at least 1,000 or more jobs that would be lost. And again, all of society is right now trying to make the delicate balance between protection of the public, individual rights, constitutional rights, the right to be employed, First Amendment right to congregate and associate. And I do think those matters generally are better left to the legislature or city councils. But again, you must comply with the Constitution. As far as the third prong that's required to be established, and it's a technicality, but it says the damage to the plaintiffs outweigh any perceived inconvenience to the city of Columbus, not the public, but the city of Columbus. And I think that's true here because Judge Fry is going to revisit this. If there's expert testimony supporting all this, if the governor shuts down or puts in place the same rule that the city council did, then that could all change. And this could be litigated. Maybe they could tailor an ordinance that's better than this one. Again, I think it's somewhat arbitrary to single out restaurants and bars, and I think 10 p.m. is arbitrary. And if there's evidence supporting 10 p.m., then let that be done in a full hearing rather than in some summary matter. Here, it's better to have all that evidence out. But in the meantime, if I didn't grant this order, and in 14 days or 20 days when there's a hearing, I think a lot of these businesses would be shut down and a lot of people out of work. Now, finally, there has to be a showing that the public interest is being served by granting the injunctive request. And some people may say, well, how is the public interest being served when we have a public interest in health concerns and COVID being spread? But the public interest is served because we have a rule of law, and the public interest is served when the Constitution is followed, and we have to do that. So, and we also have a public interest in having people employed, and again, this is a delicate balance, but I think it's better to have a full hearing later, and we'll see what the governor does on Thursday. We'll see if there's a link to the rise in COVID in Central Ohio because of bars. I am going to require a $1,000 bond. I'm going to ask you, Mr. Hasty, to draft the appropriate order electronically and make sure that the court's closed now, the clerk's office, but let Mr. Sperlazza review that order, but it should comport with my order today, and then you'll both have to see Judge Fry, and he can revisit this. He may have a difference of opinion than I do, and it is his assigned case. But again, professionalism was great. I appreciate both sides. It's good to have good lawyers. It's good to have the arguments all fleshed out. And doing what I think is right under the law, not always right, but I think this is the right decision today. So thank you all. That will adjourn the court.
Your Honor, the bond requirement, is that immediate? Or I don't know if I can even go pay it right now, but
as long as you pay it tomorrow, but I am the order is effective now, pending the posting of the bond within 24 hours.
So it's good for tonight, and that's
correct. So I'm enjoining the enforcement of the law today, tonight, as long as pending posting the bond. You don't post the bond tomorrow, then my order is not going to be effective. But I'm sure your clients will pay the $1,000 when the clerk's office opens. But I am enjoining the law.